Can you even terminate the contract and leave it, or are you stuck forever? This is just one of the questions that everybody should be asking themselves before they sign the dotted line for whatever contract is in front of them. And contracts are everywhere. They're there when you get a job. They're there when you buy a house, when you lease a car, when you buy a new phone and you enter into a plan with AT&T or Verizon, or maybe even when you're selling your used car to a stranger out there in the world. And now with the advent of AI and DIY contracts, which as a transactional lawyer is a nightmare to me, contracts are going to become even more commonplace. And that's why it's important that everybody understand what I'm talking about in this video, and that is, what are the things that you need to know before you sign a contract. And the first principle is termination. Who gets to terminate the contract and under what conditions? And if the contract is terminated, then what happens? This is so important because termination gets at your freedom. You may not realize that when you're signing on to a contract, you may be signing up for a 1-year term or a 2-year term or a 3 or 4 or a 5-year term with no ability for you to cleanly walk away from that agreement. Now, usually this is more relevant in the employment and the service-based context. I'll give you an example. Sometimes content creators want to work with a social media agency. The social media agency promises them brand deals and money and better posturing in the market in exchange for the agent getting 20% of usually everything that the creator earns from social media. And these agencies often force creators to sign on to 1-year, if not multi-year terms, with no way for the creator to terminate the contract and walk away. And that means that in some cases, when the agent isn't really doing a good job and the creator is dissatisfied, the creator has no clear way to leave this contract. They're just gonna have to either wait around for a couple of years until the term is over, or they'd potentially be in breach of the contract by terminating it early and walking away. Of course, if this is happening to you or somebody you know, then you should reach out to a qualified attorney like myself who can help you navigate the process. But the bottom line is that termination clauses are very important because you should understand going into the contract how you can end it if things don't end up going well. And not only should you understand how the contract can be terminated, but you also need to know what happens if it's terminated. And I say that because sometimes termination clauses come with penalties. If one person terminates it, they owe the other person $500. If the other party terminates it, they owe the other party $1,000. The best example of that type of operation is a non-refundable deposit. When you give a business a non-refundable deposit, what you're basically saying is, if I terminate the agreement that we have, I'm agreeing that you're going to keep the non-refundable deposit. I'm not going to get it back, and that's just the terms of the deal. So ask yourself when you're looking at these contracts, how can I leave this agreement? And if I do leave, what happens? The second principle, where can you sue if you're even allowed to sue under this contract? Oftentimes, contracts will include what is called a choice of law provision. And the choice of law provision dictates in advance what state's laws will govern if there is a dispute under the contract. And this matters. This matters a lot because let's say I'm in California and then somebody else is out there in New York and we sign a contract and it says that New York law governs. Well, you know what that means? That means that in most cases, I can't sue them under this contract in California. Instead, I now have to find a New York lawyer to go file suit in New York, and the law underlying the dispute is going to be New York state law rather than California state law. And different states have different sets of laws. This should come at no surprise. Some states, like California, tend to be more protective of things like consumer rights and tenant rights and employee rights, relative to other states like Texas, which have less intense regulatory regimes in these spaces. And that's why it really matters what jurisdiction's laws will govern if you eventually have to sue each other. But it's not just which state's laws govern that's important, it's also how you're allowed to sue them. These days, it's become very popular to include a mandatory arbitration provision in contracts. And what a mandatory arbitration clause does is forces both parties to resolve any dispute in what is called binding arbitration rather than the court system. And there's a lot of reasons for this. Arbitration sometimes can be cheaper. Most importantly, arbitration is private and it's confidential, meaning that if you sue somebody, the press is not going to be able to find out. The media doesn't know that this lawsuit even happened. These types of clauses got a lot of attention during the Me Too movement because at the time, a lot of big employers like Google, as an example, had these mandatory arbitration clauses in the employment agreements that all of the employees signed. And it mattered because some of these employees wanted their litigation against Google to be public. They wanted people to see. They wanted a jury of their peers to weigh in on the decision making of their case. But instead, they had to go through arbitration. The Supreme Court has upheld repeatedly the validity of these mandatory arbitration clauses. And when you go into arbitration, you don't get the benefit of a jury of your peers. Instead, Instead, you hire an arbitrator who is typically a retired attorney or a retired judge who will rule on the case one way or the other. And on top of this, if you want to bring a case in arbitration against another party because you signed a contract that has that mandatory arbitration, it's going to cost you probably tens of thousands of dollars just to initiate the arbitration against the other party. And that's because arbitration is a private enterprise and it's not run by the state in the same way that the state court and the federal court systems are. And that means that if you want this arbitrator to handle your case, you pay them whatever their rate might be. And you rent out a space where the arbitration is going to be taking place. And sometimes this process can be more expensive than launching a state court or a federal court lawsuit. It's pretty common in the employment context these days for employers to allow the employee to either opt in or opt out of arbitration provisions, in part because of the activism and the pressure that I mentioned earlier, coming from people who don't want to have to resolve disputes with their employer in this private, confidential context. So think about this when you're looking at these contracts. What jurisdictions' laws govern? And is there mandatory arbitration, or sometimes called mandatory mediation, that is required instead of going through the state and federal court system? Now, sometimes you might not even be able to sue the other party, and you should be aware of that before you go bungee jumping or jumping out of a plane to skydive. In what are typically called liability waivers or liability releases, you are waiving in advance the ability to go after the other party in case you get hurt or injured in whatever context it is that you're dealing with the other party in. Most of the time, this is in contexts like extreme sports, bungee jumping, snowboarding, skiing, snowmobiling, a lot of snow. Now, to be clear, you might not be able to do anything about signing this waiver because a lot of the times these businesses have no choice. They're not going to let you do the activity with them unless you sign the waiver, which is kind of fair. They're providing this service, and if they were going to get sued by every third person who walked in the door because they were sore or maybe their neck hurt after they did this strenuous activity, then they'd be out of business really quickly. But at the same time, there might be another circumstance that comes up in your life where you're signing a liability waiver when it doesn't make any sense to. Sometimes I've been asked to sign liability waivers when I'm at an event conference where everybody's just networking. Like, I don't know why I'm signing this. Is the coffee going to scald me like that famous McDonald's case? Or maybe I'm going to trip down the stairs? Like, I don't know. But the point is, you should know that when you sign these types of waivers, you're giving away the right to go after this other party. Now, I want to make clear I'm generalizing, and if the other party acts with malicious intent or gross negligence, then oftentimes you can still sue them, and the waiver is not always going to be a defense for them. But still, keep your eye out for these. The numbers. For the love of all that is holy and legal and jurisprudential, look at the numbers in the contracts that you're signing. Oftentimes, a contract is used to document some sort of business transaction or deal. And oftentimes, these deals involve numbers. Number of dollars, number of social media posts, number of days. Quadruple check these numbers. Not just because the other party may have pulled a fast one on you and changed the deal terms without you realizing it, but also because people make mistakes. Paralegals, attorneys like myself, we're not perfect, and whatever ends up being signed, even if there was a typo in that document, will be the governing legal document between the parties going forward. There isn't really a good argument for you to say, well, we actually agreed on $2 million. This says $10 million in the contract, but that's just a mistake. In the employment context, especially if you're working in the startup world, are you signing up to a non-compete? President Biden tried to invalidate non-compete clauses everywhere in the United States, but that regulation has been suspended and is going through the court system. And that means that depending on which state's laws govern the contract that you signed, a non-compete clause could still be valid against you. And this really matters. I've had many clients who have come to me and said, Julian, I just worked on this startup. My teammates and I don't get along. I want to start my own venture in the same space. Can I do so? And I look at their employment agreement, and oftentimes the answer is no. And the answer is no because they signed onto a non-compete clause that prevents and bars them from working in the same industry and space as that first company for sometimes up to 12 months after they stop working at that company. Again, this depends on which jurisdiction's laws are governing, but you should know about this before you sign the dotted line, because if you're giving up the right to start a competing venture after you leave the current venture, that should be part and parcel to the negotiation about your compensation. Are you giving up name, image, and likeness rights? There was a time that I had a client go to an event by a major social media company. And the event was mainly networking for people within the creative team of the company with creators so that they could build better relationships. And a few months later, my creator spotted their face in an unrelated ad by that company that they had no idea was running. At this point, the creator came to me and said, Julian, we need to get this taken down because I never authorized that. And I responded and said, did you ever sign anything with this company? And they provided me with a document that they had signed prior to going to this event. And in that event contract, there was a broad license to use the creator's name, image, and likeness for marketing. Now, maybe you don't care about this because, hey, you want to be famous. If they want to use your name, image, and your likeness, by all means, use it. Put my face on the Times Square billboard. I don't care. But you should care. And it has nothing to do with fame. Anytime a brand is using your name, your image, your likeness, you should be negotiating for that. There is value in your specific name, image, and likeness. And too many people give it away freely, not just to big companies, but also to small companies, photography companies, videography companies, event venue rental companies. These contracts often have broad name, image, and likeness licenses that give them the right to take any footage of your event or of you and then use it as they will without your consent. These types of terms can be negotiable. Now, that doesn't mean they're going to use it, and of course, oftentimes they probably don't. But why give that to them? Look out for name, image, and likeness clauses. And lastly, confidentiality and non-disparagement. Now, confidentiality should speak for itself. Do you care about the information and the relationship that is being discussed and contemplated by the contract being confidential, or do you not care? Sometimes you might really care because you want the ability to speak to your friends about this contract, to speak to an advisor, to talk about it on social media. Or other times, you just might not care at all. You would rather it be confidential even because you don't want information out in the public eye and you want it to be kept confidential. Think about that when you're looking at the contract you're signing, and also take a look and see if there even is a confidentiality clause in there, because if there is, then you should know about it in advance. And a related point is a non-disparagement clause. And non-disparagement clauses are important because they're going to force you to shut up about the other party and prevent you from speaking about the other party in a negative or an unflattering light, sometimes in perpetuity forever. Now, of course, nobody is truly forcing you to shut up. You can always go out there and start talking crap about the other party, even if you did sign a non-disparagement agreement. But the reality is that if you do that, you are breaching the contract and you're opening yourself up to damages if they decide to come after you and sue you. So evaluate whether or not a non-disparagement clause is in the contract at hand, or maybe if you want to add it into your contract. Some final thoughts on this topic before we wrap. I alluded to this earlier in the video, but oftentimes contracts are non-negotiable. Big companies like AAA or AT&T or Verizon, they're going to give you the contract, and if you ask to negotiate it, they're going to respectfully say a GFY. That's just the unfortunate reality of the leverage of the big players versus the small players. Is it worth not signing on to these contracts because you spot some of these issues that we talked about? That's up to you. I'm guilty as charged for signing agreements on a weekly basis without negotiating them at all, usually because I know that I'm not going to get anywhere trying to negotiate. And trust me, I've tried. It's not the end of the world if you can't negotiate these contracts, but still I think it's important for you to understand what it is you're giving up and what you're signing when you do sign on the dotted line. Now, with tools like ChatGPT, everybody feels like they can use it as their own lawyer. And while having ChatGPT give you some bare bones contract is certainly better than doing a 2-sentence contract on the back of a McDonald's napkin, ChatGPT is still not a lawyer. A positive from AI like ChatGPT is that you can ask it to explain contract terms to you as if you're a 5-year-old. So if something is really confusing you in a contract, then copy and paste the clause into chat and ask it, can you explain this to me like I'm 5? To that end, AI is great. If you're facing a legal issue, or if you're thinking of starting a business or drafting a contract, and you're thinking to yourself that I need to get a lawyer for this, then reach out to me anytime, and I'm more than happy to help. My email is right here, and I help folks with all different spans of legal issues, from trademarking to business formation to contract review and negotiating to even litigating cases in the California court system. Even if you think I might not be able to help, reach out and I will find you somebody who can. If you found this helpful, I'd be very grateful if you hit that sub button, leave a comment with any additional thoughts or corrections or context, and I'll see you next time.